Seniors, pay close attention. Senate Bill 2184, known as the Senior Fraud Protection Act, has officially been signed into law. Here is what they are keeping from you. Stop what you are doing right now, because what you are about to hear could return thousands of dollars to your pocket and shield everything you have devoted a lifetime to building. The majority of American seniors will never even learn this occurred. A groundbreaking piece of legislation has just passed through the United States Senate and is quietly being recognized as the most focused and most significant senior fraud protection law ever enacted at the federal level. It is known as Senate Bill 2184, the Senior Fraud Protection Act. And if you are older than 60, if you are supporting an aging parent, if retirement is on the horizon, or if you are already depending on Social Security and Medicare, this law touches your finances, your safety, your property, and your future directly. But here is the part that ought to make your blood boil. The major news networks are barely scratching the surface of this story. They gave you the headline and then moved straight into the next story. Meanwhile, millions of seniors throughout America have absolutely no clue what is actually contained in this bill, what they are now legally owed, or, and this point is absolutely critical, which deadlines they could lose if they do not move quickly. Some protections built into this law activate automatically. Many of them do not. Some demand that you register. Some require you to update your existing records. Some come with enrollment windows that close permanently if you hesitate too long. So today we are going to lay it all out clearly. Every significant change explained in straightforward language. No legal terminology, no political agenda, just the real, practical, dollar and cent facts about what just shifted for American retirees and their families. Get a pen ready, write things down, and share this with every senior person you care about. Let us dive in. First, let me give you the background on where this bill originated and why it carries so much weight at this particular moment. For generations, American seniors have been quietly losing the most critical battle of their financial lives, not to market collapses or poor investment decisions, but to organised, deliberate, and relentless criminal fraud. Each and every year, older Americans lose an estimated $36 billion to financial fraud and exploitation. $36 billion. That is not an accounting error. That is not a minor detail buried in a footnote. That is more money than the annual operating budget of certain federal agencies draining out of the retirement accounts, Social Security funds, pension payments, and life savings of individuals who spent 40 and 50 years constructing what they had. And the response from federal legal and enforcement systems has been, for decades, inadequate, fragmented, reactive, and chronically underfunded. Senate Bill 2184 changes all of that. It is the most thorough, best resourced, and most operationally serious piece of anti-fraud legislation ever aimed specifically at defending older Americans. And the reason we need to examine it in depth is because the news cycle races forward relentlessly. The genuine money, the real protection, the truly life-altering meaning of this law lives in the specifics, and the specifics are precisely what no one is bothering to explain. Let us walk through every major change this law introduces, beginning with the one that is already sending shockwaves through the fraud industry. The first major change is the establishment of the Senior Fraud Prevention and Response Fund, a dedicated, permanent, protected federal funding stream of $400 million, annually directed exclusively towards senior fraud prevention, investigation, prosecution, and victim recovery efforts. This is not a grant that requires annual renewal. This is not money that can be quietly rerouted when another issue rises in priority. It is a permanent, protected funding stream written directly into the legislation that cannot be diverted for other uses. $400 million every year devoted to nothing except shielding seniors from financial predators. What does that money actually accomplish in real, everyday terms? It funds the recruitment of 500 new specialised fraud investigators at the Federal Trade Commission, the FBI, and the Department of Justice, all of whom have a single purpose. Not general financial crime, not broad white-collar fraud, but specifically elder financial fraud. Investigators trained in the precise methods predators use against older individuals, trained to identify patterns, trained to operate faster than the existing system allows, and trained to prioritise the cases that currently vanish into a backlog and are never resolved because there simply are not enough personnel to address them. The fund also establishes 37 new senior fraud rapid response units distributed across every federal circuit, meaning that when a fraud complaint arrives from a senior in rural Alabama or suburban Oregon, there is now a trained, funded, dedicated unit nearby enough to respond within 72 hours, rather than adding the complaint to a waiting list that drags on for months. And here is the element that will genuinely make the largest difference in the lives of people who become victims: the Victim Recovery Fund. Written into S2184 is a provision allowing the court, following the conviction of a fraud perpetrator who specifically targeted seniors, to order restitution from a federal victim recovery fund before the perpetrator's personal assets are fully seized and liquidated. That means a senior who lost $30,000 to a romance scam does not have to wait through the perpetrator's conviction, sentencing, restitution order, actual payment and fund clearance, a process that routinely stretches 3 to 7 years and frequently produces nothing because the criminal holds no significant assets. Under this law, verified victims aged 65 and older can apply for interim recovery directly from the federal fund while the criminal case is still moving through the courts. The money does not disappear inside the legal machinery. It is returned to the person who lost it. The second major change confronts something that financial predators have been exploiting for years, with virtually no repercussions: the Social Security number security gap affecting seniors. At this moment, your Social Security number, the 9-digit master key to your entire financial identity, is involved in more transactions, applications, and systems than at any previous point in American history. And for seniors, particularly those who do not actively monitor their credit or check their financial accounts on a regular basis, the gap between when a Social Security number is stolen and when the victim discovers the theft can stretch across months or even years. During that window, the destruction multiplies. New credit lines are opened. Tax refunds are fraudulently rerouted. Medicare benefits are claimed by identity thieves submitting bills for services that were never delivered. S2184 creates the first mandatory real-time senior identity alert system. Here is the way it functions. The Social Security Administration will now cross-reference every Social Security number belonging to someone aged 62 or older against a database of recognized fraud patterns and suspicious activity indicators on a daily basis. When a red flag appears, an alert is dispatched immediately to the senior's registered contact, not to a credit bureau that requires months to process the information, not to a collections agency that discovers the problem after the damage is already complete, directly to the senior or their designated trusted contact within 24 hours of the suspicious activity being identified. If you do not currently have a My Social Security account at SSA.gov, creating one this week is now among the most important financial protection actions you can take, because the identity alert system operates through that account. If you do not have one, the alerts have no destination. And for seniors who feel uncomfortable setting up the account independently, S2184 funds a network of free in-person assistance sessions at every Social Security office and every participating public library across the country. Walk in, bring your Social Security card and a photo ID, and a trained assistant will establish your account, register your trusted contact, and activate your alert preferences at absolutely no charge. The third major change involves banks, credit unions, and every financial institution that manages accounts belonging to seniors. For years, financial institutions have occupied a uniquely powerful position in the fraud protection landscape. They are frequently the first place where fraud becomes visible. A sudden large withdrawal, a wire transfer sent to an unfamiliar destination, a new signatory added to a long-standing account. But they have functioned under an inconsistent and frequently ineffective patchwork of voluntary guidelines and state-by-state regulations, governing when and how to step in. S2184 establishes the first unified national standard for how financial institutions must behave when suspected elder financial exploitation is identified. Under the new legislation, any bank, credit union, brokerage, or financial services company holding accounts belonging to customers aged 62 or older must now put a specific senior account monitoring protocol into operation. Every institution must designate and train a senior account protection officer at every branch location. Every institution must maintain a written policy detailing how to respond to a suspected exploitation situation, including specific hold procedures, specific reporting obligations, and specific timelines for notifying the victim. And every institution that identifies a transaction pattern consistent with financial exploitation of a senior must file a suspicious activity report within 48 hours and simultaneously reach out to the account holder directly, rather than sitting back and waiting for the account holder to contact them first. The law also introduces genuine liability for institutions that fail to comply with these protocols. Under prior law, a bank that neglected to flag an obvious exploitation situation faced virtually no consequences beyond damage to its reputation. Under Section 2184, a financial institution that fails to follow the new mandatory protocols and a senior experiences documented losses, as a direct result, can be held financially responsible for a portion of those losses. That represents a fundamentally different incentive structure. Banks that were previously passive bystanders are now legally required to take an active role, and banks that fall short of that standard have a compelling financial reason to make changes. The practical significance for you as a senior account holder is substantial. Within 90 days of this law taking effect, contact your bank or credit union and ask 3 specific questions. First, who serves as your designated senior account protection officer? Second, what is the specific transaction alert threshold applied to accounts like mine? Third, how do I officially register a trusted contact on my account so that if a suspicious transaction appears, there is someone you can reach without delay? Those 3 questions position you as an engaged and aware account holder and create a documented record of your awareness that can carry real weight if you ever find yourself in a disagreement with the institution over how they managed a potential exploitation situation. The 4th major change confronts what the FBI has identified as the most rapidly expanding and most psychologically crushing form of elder financial fraud, romance and relationship scams targeting isolated seniors. At this moment, no specific federal criminal statute exists that targets relationship-based financial fraud against older adults. Perpetrators are charged under general wire fraud, mail fraud, or money laundering statutes when they face charges at all. The penalties do not reflect the distinctly predatory nature of pursuing a grieving widow or a lonely widower with a carefully constructed emotional relationship designed from the beginning to drain their savings. The sentences are identical to those for any other financial fraud case of the same monetary value, regardless of the victim's age or the particular vulnerability that the predator deliberately exploited. S2184 creates a brand new standalone federal criminal offence called elder emotional manipulation fraud. This new statute specifically makes it a crime to build a romantic or deeply intimate relationship with a person aged 65 or older for the specific purpose of financial exploitation, with intensified penalties when the stolen amount surpasses $25,000, when the victim was living alone at the time of the offence, when the perpetrator deliberately used the victim's grief or loneliness as the central manipulation tactic, or when the victim suffered measurable psychological injury alongside their financial losses. The enhanced penalties under this statute raise the minimum federal sentence by as much as 50% above the standard fraud baseline, and they permit the court to impose mandatory restitution from the Victim Recovery Fund before the perpetrator's other legal obligations are addressed. This matters not only as a legal deterrent, which it absolutely is, but as a declaration. For the first time in federal law, a statute states plainly that targeting a lonely senior with a fabricated personal relationship is not simply fraud. It is a specific, distinct, and far more serious category of predatory crime that the federal government will pursue with greater force and punish with greater severity than it has ever done before. The 5th major change concerns Medicare fraud, which is simultaneously one of the largest contributors to cost across the entire federal healthcare system, and one of the most direct ways that seniors suffer personal harm from financial crime, both as victims of identity theft and as beneficiaries who lose access to services they genuinely need because fraudulent billing has already consumed their coverage limits. S2184 dedicates $120 million specifically to Medicare fraud detection and investigation, including the deployment of artificial intelligence monitoring systems capable of identifying billing patterns consistent with fraud within days rather than the months or years that the current manual review process demands. The law also creates the first Medicare Fraud Victim Recovery Program for seniors who have experienced documented losses of coverage or access to care that resulted from fraudulent billing submitted under their Medicare number. If your Medicare number was used to submit claims for services you never received, and you subsequently lost coverage for services you genuinely needed because your benefit limits were exhausted by those fraudulent charges, you may now file a recovery claim that will be processed within 60 days, and that can result in the restoration of your benefit access, along with an additional credit applicable to future covered services. If you have ever received an explanation of benefits statement from Medicare listing charges for services you do not recall receiving, that document is exactly what you need to preserve. Begin a dedicated file right now. Every EOB statement that contains something unfamiliar represents a potential recovery claim waiting to be submitted. S2184 makes the recovery process genuinely accessible for the first time in history. The sixth major change involves what the law designates as the Senior Housing Fraud Protection Provisions, and these address a category of financial exploitation that has been accelerating in recent years, as the senior housing market has grown increasingly profitable and increasingly predatory. Reverse mortgage fraud, home repair schemes, fraudulent property deed transfers, and exploitative senior living facility contracts have devastated thousands of families who are confident they were making sound decisions about their most significant financial asset, which is their home. S2184 introduces 3 new protections in this area. First, a mandatory 3-day cooling-off period for any financial transaction involving the primary residence of a person aged 65 or older, during which the transaction cannot be completed and the senior must receive written notification of their right to rescind. Second, mandatory independent legal review for any deed transfer or reverse mortgage transaction involving a senior account holder, with the cost paid by the institution or party seeking to finalise the transaction rather than by the senior themselves. Third, a new federal certification requirement for any organisation marketing housing services or housing transitions specifically to seniors, with loss of certification and prohibition from participation in federal programmes for any organisation found to have engaged in deceptive practices. The seventh and final major change is the one I most need you to absorb clearly, because it is the change that requires action from you, not eventually, but this week. S2184 establishes a National Senior Fraud Registry, a voluntary opt-in database administered by the Federal Trade Commission that allows seniors to formally register themselves as eligible for enhanced protections under the law. Once enrolled, your name enters a database that financial institutions, telephone carriers, and verified organisations must consult before completing certain high-risk transactions. If your name appears in the registry, those transactions require additional verification steps before they can move forward. It is not a flawless shield, but it is a meaningful, extra layer of protection against the automated, high-volume fraud operations that use stolen personal data to push transactions through before any human review can take place. Registration costs nothing. It takes roughly 15 minutes to complete. It is handled through the Federal Trade Commission website at ftc.gov. You will need your social security number, your date of birth, and contact information for a trusted individual in your life who can be reached if a transaction tied to your registry enrolment is flagged for review. Once registered, you receive a confirmation notice and a unique registry reference number that you can share with your bank, your Medicare plan, and any other institution where you wish the enhanced protections to apply. Here is what you need to do immediately, and I mean this week, rather than next month or when you find the time. Visit ftc.gov and enroll in the National Senior Fraud Registry. If you are not at ease completing this process online, you may call the FTC's Senior Fraud Hotline at 1-877-382-4357 and finish the registration by phone. Go to ssa.gov and create or verify your My Social Security account. If you need in-person assistance with this step, your local Social Security office and participating public libraries now provide free assisted setup sessions under S2184. Contact your bank and pose the 3 questions mentioned earlier. Who serves as the Senior Account Protection Officer? What is the transaction alert threshold for my account type? How do I register a trusted contact on my account? Pull out your Medicare explanation of benefits statements from the past 12 months and review them for any charge related to a service you have no memory of receiving. If you find one, contact Medicare at 1-80-06334227 and report it. Under S2184's new Medicare Fraud Victim Recovery Program, you may qualify for benefit restoration. And here is the most critical warning I can offer before wrapping up. Scammers move with extraordinary speed. Within days of major legislation like this being signed into law, criminal organizations are already building scripts around it. Right now, as you are watching this video, there are individuals placing calls to seniors throughout America claiming to represent the FTC, Medicare, or the Social Security Administration, and offering to help them register for the new protections included in Senate Bill 2184. Every single one of those calls is a scam without exception. The federal government does not place cold calls to seniors offering to help them register for new legal protections. Registration is completed by you voluntarily through official government websites or official government phone numbers that you personally look up and dial yourself. The FTC does not call you. The real FTC number, the one you dial yourself, is 1-877-382-4357. The Social Security Administration does not call demanding that you take immediate action. The real SSA number, the one you dial yourself, is 1-800-772-1213. Medicare does not call requesting your card number or personal details. The real Medicare number, the one you dial yourself, is 1-800-6334227. If anyone contacts you by phone offering assistance in signing up for the new senior fraud protections and requests any personal information whatsoever, end the call immediately. Then contact a family member or your trusted contact and describe exactly what happened. Let me close by asking you to reflect on your own experience. Think about the moments when it felt like the system was never designed with you in mind. Perhaps it was the phone call that nearly wiped out your life savings. Perhaps it was the account statement showing a charge from a company you had never heard of. Perhaps it was the moment you realised someone had been quietly taking money from your accounts over time and you had no idea who to call or where to begin. Perhaps it was watching a neighbour, a close friend or a parent endure something similar and feeling completely powerless to intervene. Senate Bill 2184 does not eliminate every problem that exists. No single piece of legislation can accomplish that. But it is a genuine, serious and well-resourced effort to provide every senior in this country with a stronger defence against the individuals who have built an entire criminal enterprise around targeting you specifically. And more than anything else, it is a signal that legislators examined the true scale of this crisis and declared that enough is enough. The predators will not surrender quietly. They will adapt their methods. They will discover new angles of attack. They always have and they always will. Which is precisely why staying informed, enrolling in every protection this law provides, and passing this information along to every senior you care about is not merely helpful, it is absolutely essential. Awareness is power when it comes to elder financial fraud. It is also the single most dependable form of protection you have available to you. Share this with every senior you